Commissioner Holzman is here.
Thank you, Commissioner Holzman. I think we're going to have a delayed start this morning because we do not have a court reporter yet.
Court reporter's here.
Oh, I was under the impression that you were going to be in person.
Oh, I'm sorry. Nope, I'm here on WebEx.
Okay, is this Miss Bench?
No, this is Miss Taylor.
Okay, Miss Taylor. First name?
Tracy?
Okay, well, you'll let me know if you can't hear anything.
Sure.
Okay, it is 9 a.m. Let's go on the record. Good morning. Today is February 7th. The current time is 9 a.m. This proceeding is being held in room 310 of the Governor Office Building, as well as electronically via WebEx. The Commission has set aside this time for a hearing in the matter of the request of the Empire District Electric Company, doing business as Liberty, for authority to file tariffs increasing rates for electric service provided to customers in its Missouri service area. And this is file number ER-2021-0312. My name is John Clark. I'm the regulatory law judge presiding over this hearing today. We also have some commissioners present. Currently, I see that we have been joined by Commissioner Holzman and Commissioner Coleman. Other commissioners and the chairman may drop in and drop out to hear particular testimony or particular evidence.
Good morning, Judge. This is Chairman Sylvie.
Thank you, Chairman. I apologize for not seeing you. And the chairman is with us as well. I'm going to remind everybody to mute their mics when they're not speaking, because otherwise it creates a lot of noise. And if you are participating via WebEx, I'm going to ask that you mute yourself. If you're participating via phone, I'm going to ask that you mute yourself until such time as you need to speak. Now, because of the ongoing pandemic situation, we're going to do the best we can in this case to socially distance in this room. Masks are not required, but they are encouraged. I'm going to say I also received word that Commissioner Kolkmeyer will be joining us momentarily. At this time, I'm going to ask counsel for the parties to enter their appearance for the record on behalf of Liberty Utilities.
Diana Carter for the Empire District Electric Company, and also Dean Cooper of Brighton, Clarendon, and England.
Now, do you want me to call you Empire District Electric Company or Liberty, or do you care?
We do not care.
Okay, I'll probably go with Liberty. For the staff of the commission?
Kevin Thompson and Nicole Murs for the staff of the Missouri Public Service Commission, Post Office Box 360, Jefferson City, Missouri, 65102.
Thank you, staff. For Midwest Energy Consumers Group?
Good morning, Your Honor. David Woodsmall on behalf of MECG.
Thank you, MECG. Anyone here for the Empire District Retired Members and Spouses Association?
Yes, Your Honor, Terry Jarrett of Human Offices, appearing on behalf of the Empire District Retired Members and Spouses Association.
And then you go by EDRA?
Yeah, EDRA, EDRA.
Okay. Thank you, EDRA. The Empire District Company.
I'm sorry?
Did I interrupt you? I apologize.
No.
The Empire District Electric Company SERP retirees.
Good morning, Your Honor. David Woodsmall for the SERP retirees.
Thank you, Mr. Woodsmall. New Missouri filed a motion to be excused, and that motion was granted. The City of Ozark filed a motion this morning to be excused, and that motion will be granted. Moving on to preliminary matters, are there any pending motions that need to be addressed?
Judge, would you like an entry from the Office of Public Counsel?
I apologize. Office of Public Counsel.
Nathan Williams, appearing on behalf of the Office of the Public Counsel and the public.
Thank you, Mr. Williams. I'll get back to preliminary matters. Are there any pending motions that have not been addressed? I see no hands. Are there any evidence that the parties want to enter now that are undisputed? Or do you just want to wait till the time?
Judge, it may be easier to go ahead and put in all of our pre-filed testimony now. The only witnesses that take the stand are on the one issue of class cost of service.
Are there going to be any objections to entering testimony on behalf of the witnesses?
Not from the Office of Public Counsel.
Staff has no objection.
The company has no objections.
EDRA has no objection. No objection.
And Mr. Wildsmall, I assume that's no objection from both your clients?
Yes.
Okay. So there are no objections. What evidence would we like to go ahead and admit? What testimony?
For the company, we circulated the exhibit list, and we have paper copies up there for the court reporter. Judge, would you like me to go through the list or just refer to the exhibit list?
I would like to go through the list.
Okay. For the company, we have Exhibit 1, direct testimony of Tim Wilson. Exhibit 2, rebuttal testimony of Tim Wilson. Exhibit 3, in public and confidential version, Tim Wilson, the rebuttal testimony. Exhibit 4, in public, confidential, and highly confidential version, Todd Mooney, direct testimony. Exhibit 5, Todd Mooney, rebuttal testimony. Exhibit 6, in public and confidential version, Todd Mooney, the rebuttal testimony. Exhibit 7, public and confidential, Sean Rooney, direct testimony. Exhibit 8, Sean Rooney, rebuttal testimony. Exhibit 9, public and confidential, Sean Rooney, the rebuttal testimony. Exhibit 10, public and confidential, Aaron Dole, direct testimony. Exhibit 11, Aaron Dole, rebuttal testimony. Exhibit 12, Aaron Dole, the rebuttal testimony. Exhibit 13, Jeffrey Westfall, direct testimony. Exhibit 14, Jeffrey Westfall, the rebuttal testimony. Exhibit 15, Chad Hook, direct testimony. 16, Chad Hook, rebuttal testimony. Exhibit 17, in public and confidential version, Chad Hook, the rebuttal testimony. Exhibit 18, public and confidential, Drew Landau, direct testimony. 19, Jill Schwartz, direct testimony. 20, Tisha Sanderson, direct testimony. 21, Tisha Sanderson, rebuttal testimony. 22, Tisha Sanderson, rebuttal testimony. Exhibits 23, 24, and 25, Charlotte T. Emery, direct testimony, rebuttal testimony, and rebuttal testimony. Exhibit 26, public and confidential, Zachary Quintero, direct testimony. Exhibit 27, Greg Tillman, direct testimony. 28, Greg Tillman, rebuttal testimony. 29, Greg Tillman, rebuttal testimony. Exhibit 30, public and confidential, Todd Charter, direct testimony. 31, Todd Charter, rebuttal testimony. Exhibit 32, Eric Fox, direct testimony. Exhibit 33, 34, 35, John Reed, direct testimony, rebuttal testimony, and rebuttal testimony. And our witness who will be taking the stand this morning, Exhibits 36, 37, and 38, Timothy S. Lyons, direct testimony, rebuttal testimony, and rebuttal testimony. 39, John Harrison, direct testimony. 40, John Harrison, rebuttal testimony. 41, John Harrison, rebuttal testimony. Exhibit 42, Nate Hackney, direct testimony. 43, Nate Hackney, rebuttal testimony. 44, Nate Hackney, rebuttal testimony. Exhibits 45, 46, and 47, Dane Watson, direct testimony, rebuttal testimony, and rebuttal testimony. And Exhibits 48 and 49, James Fowler, direct testimony and rebuttal testimony. And Exhibits 50, 51, and 52, Frank Graves, direct testimony, rebuttal testimony, and rebuttal testimony. And that should be all the exhibits for the company.
Okay, is that what everybody was expecting? Is there anybody who wishes to object to admitting any of that testimony onto the hearing record? Bear with me just a second. Okay, so how many pieces of testimony total?
52, but some of those have different versions.
You mean public confidential and highly confidential?
Yes.
Okay. Okay. Exhibits 1 through 52 will be admitted onto the hearing record for liberty. Okay, next let's go with the commission staff.
Thank you, Judge. At this time, we would tender Exhibit 100, the direct testimony of Amanda McMillan. 101, public and confidential staff cost of service report. 102, staff accounting schedules. 103, staff's corrected.
Slow down just a second. Slow down just a second, I'm sorry. Let's go back to staff's cost of service.
Okay.
And that's public and confidential, correct?
Yes, Judge.
All right, go ahead.
Exhibit 102, staff's accounting schedules.
Okay.
Exhibit 103, staff's corrected accounting schedules.
Okay.
Exhibit 104, direct testimony of Cedric Cunningham.
Okay.
Exhibit 105, public and confidential, staff class cost of service report.
Okay.
Exhibit 106, rebuttal testimony of Kimberly Boland.
All right.
Exhibit 107, rebuttal testimony of Corey Boosted.
Okay,
Exhibit 108, rebuttal testimony of Peter Chari.
okay,
Exhibit 109, rebuttal testimony of Amanda Coffer.
okay,
Exhibit 110, rebuttal testimony of Kim Cox.
okay,
Exhibit 111, rebuttal testimony of Cedric Cunningham.
okay,
Exhibit 112, public and confidential, rebuttal testimony of Syed Dinderloo.
okay,
Exhibit 113, rebuttal testimony of Scott Glasgow.
okay,
Exhibit 114, rebuttal testimony of Courtney Horton.
okay,
Exhibit 115, rebuttal testimony of Jordan Hull.
okay,
116, rebuttal testimony of Contessa King.
all right,
117, rebuttal testimony of Robin Cleathermos.
okay,
118, rebuttal testimony of Sarah Lange.
all right,
119, rebuttal testimony of Jay Lubert, public and confidential.
go ahead,
120, public and confidential rebuttal testimony of Brooke Mastrianis.
go ahead,
121, rebuttal testimony of Amanda McMillan.
okay,
122, rebuttal testimony of Mark Oligschlager.
yes,
Okay, sorry. 123, rebuttal testimony of Charles Poston. And that's public and confidential, sorry.
thank you,
124 is rebuttal testimony of Joseph Rowling, public and confidential.
go ahead,
125, rebuttal testimony of Ashley Sarver. (126) accounting schedules. 127, rebuttal of Kimberly Boland. 128, rebuttal of Cedric Cunningham. 129, rebuttal of Keith Foster. 130, rebuttal of Courtney Horton. 131, rebuttal of Sarah Lange. 132, public and confidential, rebuttal of Jay Lubert. 133, public and confidential, rebuttal of Brooke Mastrianis. 134, rebuttal of Amanda McMillan. 135, rebuttal of Caroline Newkirk. 136, public and confidential, rebuttal of Angela Niemeyer. 137, rebuttal of Mark Oligschlager. 138 is the rebuttal of Ashley Sarver. 139 is the rebuttal of Sung Jun Wang. And 140 is staff's rebuttal EMS run.
okay. Are there any objections to admitting exhibits 100 through 140 for staff onto the hearing record. I see no objections. Exhibits 100 through 140 for staff are admitted onto the hearing record.
I have copies here for the court reporter.
Thank you. If you just want to set them up there, I will see that they're taken care of. Next, for the Office of the Public Counsel.
Thank you. Jeff Mark Direct, 200 HC and public version. Jeff Mark Rebuttal, which includes rate design, Exhibit 201C and a public version. Jeff Mark Surrebuttal, 202, highly confidential and public version. Lena Mantle Revenue Requirement Direct, 203, 3 versions, HC, confidential and public.
Say that again, please.
There are 3 versions, highly confidential, confidential, and public.
No, the witness name, please. Lena Mantle?
M. Mantle.
Okay.
And then Lena M. Mantle Direct Rate Design, Exhibit 204. Lena M. Mantle Rebuttal, Exhibit 205, HCC and public version. Lena M. Mantle Surrebuttal, Exhibit 206, confidential and public version. David Murray Direct, Exhibit 207, confidential and public version. David Murray Rebuttal, 208, confidential and a public version. David Murray Surrebuttal, 209, highly confidential, confidential and public version. John S. Riley Direct, Exhibit 210. John S. Riley Rebuttal, 211, a highly confidential and a public version. John S. Riley Surrebuttal, Exhibit 212. John A. Robinette Direct, 2 versions, 213 confidential and a public version. John A. Robinette Rebuttal, 2 versions, 214 highly confidential and public. John A. Robinette Surrebuttal, 2 versions, 215 confidential and public. That's all of our exhibits, and there are hard copies up by the witness stand.
Thank you, Mr. Williams. Any objections to admitting OPC's Exhibits 200 through 215 onto the hearing record? There are no objections. OPC's Exhibits 200 through 215 will be admitted onto the hearing record. Midwest Energy Consumers Group.
Thank you, Your Honor. We have Exhibit 350, the direct testimony of Greg Meyer. Exhibit 351, and I'll note that when I sent out the exhibit list, I didn't include the confidential version, so if you're working from my exhibit list, there's a change on that. Exhibit 351 is the public and confidential version of the surrebuttal testimony of Greg Meyer. Exhibit 352, the direct testimony of Kavita Maini.
Hold on just a second. You said that was rebuttal?
That was 352, her direct.
Direct, thank you. Go ahead.
353 is her rebuttal testimony. Exhibit 354 is her surrebuttal testimony. Exhibit 355 is the direct testimony of Andrew Teague. Finally, Exhibit 356 is the direct testimony of Steve Chris. We'd offer each of those pieces of evidence, Your Honor.
Thank you. Any objection to MECG's Exhibits 350 through 356? I see none. Exhibits 350 through 356 for MECG will be admitted onto the hearing record. for EDRA.
Yes, Judge. For EDRA, exhibit number 450, both public and highly confidential, William L. Gibson, direct testimony, and exhibit number 451, both public and highly confidential, William L. Gibson, rebuttal testimony. And that's it.
And you said on the rebuttal, public and confidential?
And highly confidential.
Highly confidential, thank you. Any objections to EDRA's exhibits 450 and 451? I see none. Exhibits 450 and 451 for EDRA are admitted onto the hearing record. And finally, for the SERP retirees, Mr. Woodsmall?
Your Honor, the SERP retirees is not offering their pieces of testimony that were pre-filed.
Okay. Thank you very much. I know that took a while. I appreciate everybody going through it, but I think it will save some time down the road. Okay, I'm relying on the parties because there is a lot of confidential information in this case. If I catch it, I will immediately mute and go in camera, but if you know in advance you're going to be putting on confidential testimony, please let me know so I can go in camera for the presentation of that. And with that in mind, is there anything else I need to address before we begin opening statements from the parties? Okay, I see none, so I will go with the order as was submitted for opening statements, and that has Liberty Utilities going first for opening.
Thanks, Judge. Good morning. I am Diana Carter, the Director of Legal Services for Liberty's Central Region, which includes the Empire District Electric Company. In addition to Dean Cooper, I have with me today Charlotte Emery, our Central Region Director of Rates and Regulatory Affairs, and Tim Wilson, our Vice President for Electric, is on WebEx, in case there happen to be questions for him. We are completing a trilogy with this case. We started with our customer savings plan docket back in 2017, where the commission noted that the public policy of this state is to diversify the energy supply through the support of renewable and alternative energy sources. And this commission held, back in that 2017 proceeding, that Empire's proposed acquisition of 600 megawatts of additional wind generation assets is clearly aligned with the public policy of the commission and of this state. Next, in 2019, Empire received the requested certificates of convenience and necessity for the wind project, and this grant was based on the commission findings that there is a need for the service, that Empire is qualified and has the financial ability to provide the service, that Empire's proposal is economically feasible, and that approval of the wind project promotes the public interest. I am very proud to say that we've executed on our customer savings plan and purchased the 3 wind farms. So now we are here to complete our trilogy. To benefit all stakeholders, the Asbury coal plant has been retired, and our 3 wind projects are now online. We have Kings Point and North Fork Ridge here in Missouri, and Neosho Ridge over in Kansas. The wind farms are an investment in the future of our company, for our customers, and for local communities. The pre-filed testimony that has now been admitted into the record also explains that Empire has made other investments in our system that will continue to serve our customers for decades to come. We've installed smart meters, AMI, that will allow our customers to see their energy usage in near real time, in turn giving customers greater ability to control their energy usage and ultimately their electric bills. Coupled with management actions, AMI led to a dramatic decrease in estimated bills. We heard our customers and we heard from the commission through the discussion in our last rate case. We worked very hard to improve our customer service, moving to more advanced technology and offering more ways for our customers to interact with us. All of the revenue requirement issues are settled among the parties, with rates to be designed using an annual increase of approximately $35.5 million. Asking customers to pay more is not an easy thing to do, not for us and not for the commission. We understand that. But the stipulated rate increase here is an investment in the future that will pay off for years to come for customers, the company, and all stakeholders. And we worked hard to minimize the rate increase, first with the design of the company's initial filing, by working with all parties to reach the 4 partial stipulations. And also, as we all know, significant legislation was signed into law after we filed our rate case. And Empire was able to file the first of its kind petition in Missouri under this new securitization statute for the qualified extraordinary costs for Winter Storm Uri. And the company has also now filed a notice of intent regarding the retirement of the Asbury generating plant. Pursuant to the stipulations that are on file with the commission, rates stemming from this case will not reflect any increase related to Storm Uri, and Asbury will not be reflected in those rates. The Asbury AAO will continue, but with tracking balances reset to 0, all issues on Asbury and Storm Uri will move over to those securitization dockets. The Storm Uri and Asbury costs were removed from the company's rate request to reflect the company's election to securitize those costs in lieu of pursuing traditional rate recovery in this proceeding, and this will lead to significant customer benefits. The 4 partial stipulations resolve all but one issue in this case. Although not signed by all parties, all 4 of those stipulations have the affirmative non-objection. So those 4 stipulations could be approved now, treated as unanimous, as a near global resolution of this case. The first stipulation established some starting numbers using staff's rate base and other balances reflected in staff's rebuttal filing. And then the 4th stipulation resolve the issue of the appropriate annual revenue requirement increase. Numerous rate design issues and other matters are also resolved with the stipulation, including the establishment of tariffs to implement Empire's new transportation electrification program, various additional reports and stakeholder meetings to maintain open lines of communication, continuation of Empire's low-income pilot program and additional shareholder funding for low-income programs, and the creation of time-of-use rates for all residential and small commercial customers. The time-of-use agreement establishes a default, more limited impact time-of-use rate. It also maintains options in the form of the current non-time-of-use rate and a limited availability high differential time-of-use rate. This portfolio of rates supports the educational benefit, introducing all customers to time-differentiated rates, the value of high differential TOU rates, and increasing customer response, incenting that customer response, and provides the company with the ability to further understand our customers' response to these new rate options. With the 4 partial stipulations, only one issue remains for hearing today, the question of how Empire's stipulated revenue requirement should be allocated among Empire's customer classes. The company recommends an allocation method that considers the results of the class cost of service study consistent with the rate design principles of fairness and equity, but also considers customer bill impacts. The company's witness, Tim Lyons, will be appearing by WebEx this morning. Permitting Empire to charge reasonable rates that will allow us to recover our cost to provide electric service is an essential element of a long-recognized compact that assures the reliability of electric service. We ask that the Commission recognize the overwhelming benefits to our customers from the transformation in doing the right thing for a sustainable future for our customers. And in conjunction with the Commission's decision on the one remaining contested issue, we ask that the Commission approve the filed stipulations as a just and reasonable resolution of this case. Thank you, Judge.
Any questions from the Commission? Okay, I have no questions. Thank you, Liberty.
Thank you.
Next for opening statements is the staff of the Commission. And Mr. Thompson, is that microphone on? Yes, thank you.
Thank you, Judge. May it please the Commission. Today we are here to litigate the single remaining issue in this case, which is the area of rate design. Rate design is the process of devising prices that will collect the necessary revenue requirement from the company's customers. The particular issue under consideration today is that of class cost responsibility shifts. What does that mean? Utility customers are sorted into classes based upon various characteristics. Rates are devised for each class based upon the cost of serving the customers in that class. The goal is to match costs to cost causers so that each customer will pay an amount approximately equivalent to what it actually costs to serve that customer. Sometimes, however, rates and costs get out of alignment. In that situation, the prices charged for service no longer match the actual cost of the service. In such circumstances, some customers pay more than the actual cost of their service, and other customers pay less than the actual cost of their service. This problem is addressed through class cost responsibility shifts. This entails a percentage adjustment to the cost responsibility of each class in order to bring prices and costs back into alignment. Necessarily, this causes some rates to go up and some rates to go down. The staff and the Office of Public Counsel oppose any class cost responsibility shifts in this case, and instead support equal percentage increases. That means that everybody's rates would increase by the same percentage. Empire and MECG, on the other hand, urge the Commission to make class cost responsibility adjustments in order to bring rates back into alignment with costs. Why would staff oppose this? Rate design is guided by a complex statistical study known as a class cost of service study. In the present case, Empire submitted a class cost of service study, and the Missouri Energy Consumers Group has made certain adjustments to it. Staff believes that these studies are flawed and therefore should not be trusted. Staff is strongly opposed to class cost responsibility adjustments based on unreliable studies. The studies in question purport to show that the rates of the residential class are nearly 20% below the actual cost of serving that class. The industrial classes, on the other hand, are purportedly paying 20% more than their actual cost of service. Those industrial customers, of course, are MECG's clients. If the class cost responsibility shifts proposed by MECG and Empire are implemented, the industrial rates will go down and the residential rates will go up. Staff is of the opinion that class cost responsibility shifts should not be made on the basis of untrustworthy studies. Much better studies will be available in the future due to the new meters that are being deployed by Empire. Staff urges the Commission to leave any class cost responsibility adjustments for Empire's next rate case, when they can be made with confidence on the basis of reliable data. Thank you, Judge.
Thank you, staff. Any questions from the Commission? And I have no questions at this time. Opening statement from Public Counsel.
Thank you. May it please the Commission. My name is Nathan Williams, and I'm appearing before you on behalf of the Office of the Public Counsel and the public. As Liberty and staff have indicated we're left with one issue basically before the commission, and that's rate design. And in particular, whether or not there should be shifts in class responsibilities to increase the rates of residential customers more than other classes. It's the Office of Public Counsel's position that the customer charge for the residential customer should not be changed, and that generally rates should be increased across the board in equal proportion to all the rate elements of the different classes. The Commission should not dogmatically look at class cost of service in deciding shifts in class responsibility. It's a factor that should be taken into consideration, but it should also take into consideration that if the Commission approves the agreements in this case, there's going to be about a 6% increase in every customer, on average across the board for customers coming out of this case. And we're going to be seeing a couple of securitization cases shortly that are also going to have a rate impact to increase rates. Those are all additional factors the Commission should take into consideration, and the impact on low-income customers that COVID, as well as others that COVID has had recently, and inflation that's impacting our economy currently. Those are all considerations the Commission should take into account. Additionally, there's a reason for why the rate class responsibilities are what they are now, and it's historical. I couldn't tell you exactly why, but it didn't come about by accident. Thank you.
Thank you, Public Counsel. Any questions from the Commission? Okay, no questions from me at this time either. And while Midwest Energy Consumers Group sets up, I believe they have a presentation. And hold on, let me see how I get that presentation on. I'm not 100% sure. Bear with me while I figure out how we get this onto the WebEx. And let's go off the record for just a moment.
Very nice on time.
Your wife dressed you this morning.
Okay, we're going to make an adjustment so that everyone who's participating via WebEx can see Mr. Woodsmall's presentation, but it is going to take just a moment. Okay, let's go back on the record. I assume we can all see it now. Sorry for the technical difficulty. MECG, if you want to go ahead with your opening statement.
Thank you, Your Honor. Good morning. David Woodsmall appearing on behalf of the Midwest Energy Consumers Group. As you know, MECG represents the interests of large commercial and industrial customers in Missouri. Relevant to the Empire District Electric, MECG represents the interests of large customers being served on the general power, large power, and transmission service tariffs. As it pertains to the issues to be heard here today, each of these rate classes are paying rates that are significantly above cost of service simply to help subsidize residential rates. The obvious impact of the continued existence of this residential subsidy is to place a mammoth drain on the economic development of the Empire service area.
You want me to try, see if I can adapt with you?
Yeah.
You know what I would say?
Technology's great. Okay.
You good?
Here are the issues that I'll be discussing today during my statement. I will discuss the class cost of service studies that have been filed in this case. Specifically, I'll discuss the studies completed by both Empire and MECG. Importantly, no other party has filed a class cost of service study. Instead, staff has simply raised unfounded criticisms designed to convince the Commission to reject the unavoidable conclusions in both the Empire and MECG studies and continue to preserve the residential subsidy. Next, I'll discuss how the Commission should interpret these class cost of service studies and how they should make decisions regarding revenue allocation in this case. After this, I will discuss several of OPC's self-serving pleas designed to maintain that same residential subsidy. Finally, since the Commission has relied upon it in other Empire cases, I will discuss the competitiveness of Empire's industrial rates. As I mentioned, there were two class cost of service studies filed in this case, one by Empire, the other prepared by MECG. Importantly, both of these studies utilize the A&E method for allocating fixed production costs. This is important because the Commission just last Wednesday found that the Ameren study, which also relied upon the A&E methodology, provided the most reasonable estimate of Ameren's class cost of service. While Empire and MECG both utilized that A&E methodologies, there were originally three issues between those parties in their methodology. First, there was a difference over the manner in which the load factor portion of the A&E was calculated. In its rebuttal, however, Empire agreed to a load factor calculation that is based upon a single coincident peak. Given that resolution, that issue has now been resolved. Next, there was a disagreement between MECG and Empire over the manner in which interruptible credits should be allocated amongst the classes. Again, this has been resolved by Empire agreeing that interruptible load should be eliminated from the A&E allocator used to allocate interruptible credits. So a second point of contention has been resolved. Finally, MECG and Empire utilized a different variant of the A&E allocator. Specifically, Empire originally used a 12 NCP version that considers the peak months or the peaks from all 12 months. On the other hand, MECG originally used only the peaks from the 5 months that are within 10% of the annual peak. After some testimony was filed, both MECG and Empire agreed to a middle ground, which would consider the peaks from 8 months, 4 summer months and 4 winter months. So with that resolution, all differences between Empire and MECG's class cost of service studies have been resolved. They are in perfect alignment. And here you see the outcome of that. What this shows, without any disagreement between Empire and MECG, is that the residential class, in order just to get to cost of service, would need an 18.99% rate increase, and then any rate increase in this case would need to be put on top of that. So just a revenue neutral increase of 18.99% for residential. Who's paying for that? Who is currently paying to allow residential customers to have this subsidized rate? Basically, every non-lighting class. So the commercial class, the Casey's General Store, the pizza parlors, everybody else, you can see they're currently paying rates that are 4.2% above cost of service. The general power class, these are larger commercial customers and some small industrial customers. So you'll see Walmart's in here and pipelines and companies like that. They're paying rates that are currently 19.8% above cost of service, simply so that the residential class can have a subsidized rate. The large power class, who is this? This is the General Mills, the Tysons, the Tamcos of the world. They're all currently paying rates, you can see here, of 19.58% above cost of service, simply so residential can have a subsidized rate. And finally, the worst one, the transmission service class, currently paying rates 31.8% above cost of service, simply so residential customers can pay less than cost of service. As I mentioned, there are no disputes about the existence of a residential subsidy. Both class cost of service studies show this to be a fact. Staff didn't file a class cost of service study. Rather, staff simply stood on the sideline and leveled criticism at the MECG and Empire studies. Each staff criticism, however, has been discredited. As an initial matter, staff questioned the legitimacy of the A&E methodology. But as I mentioned, just last week, the commission said that Ameren's A&E methodology provided the best estimation of the class cost, of the cost to serve each class. So the A&E is a valid methodology. Next, staff claims that the demand data contained in the studies is unreliable. Empire's witness Lyons pointed out, however, that there is no data, no analysis, no study to support such a criticism. It's just been thrown out there, and he showed that it's not a problem. Next, staff raises a new concern and suggests that the studies are unreliable because the Empire classes are unstable due to rate switching. But as Mr. Lyons points out, quote, rate switching occurs every year, and the level that occurred in the test year did not appear to be extraordinary, end quote. Criticism number 3 here. Staff suggests that the A&E approach, the same approach just adopted by the commission, is faulty because it is heavily dependent on class peak demands. But Mr. Lyons pointed out that this is completely unfounded. As Mr. Lyons points out, given the A&E methodology and the way it was calculated, actually 57.3% of fixed production costs are allocated based upon class energy usage. Only 42.7% is on class peak demand. So it is not dependent on class peaks. If anything, it is overly dependent on class energy usage. Criticism number 4. Staff claims that Empire's class cost of service study is faulty because it allocates SPP revenues to the classes. As Mr. Lyons points out in his testimony, however, it makes sense to allocate SPP revenues on the basis of class energy usage. The same costs that are used to create SPP revenues, the operating costs, the fuel, the costs are allocated based upon class energy usage. Therefore, it only makes sense that the SPP revenues also be allocated based upon class energy usage. Finally, staff lobs a more generic criticism by just claiming that company's class cost of service study is unreliable. Mr. Lyons, in his rebuttal testimony, astutely points out, however, that the results of the study are, quote, generally consistent, end quote, with the studies in the last 2 cases. There's nothing new here. The results, the studies are done the same way. using the same data. The results are all relatively similar. There's no basis to suggest that the study in this case is unreliable when the commission has used it in the 2014 and the 2016 cases. So where are we? We have two class cost of service studies in this case. Those studies are each based on the same methodology adopted by the commission just last week in the Ameren rate case. Both of these studies now show the existence of a significant residential subsidy. Originally, MECG asked that the commission eliminate 25% of the residential subsidy. This is consistent with the two recent Empire rate cases in which the commission did that very thing. In 2014, you can see here ER-2021-0312, commission's order. The commission finds that the increase to residential rates by 25% of the needed 8.1% revenue neutral adjustment is just and reasonable. Commission used that 25% that we were originally recommending. Again, in 2016, the commission approved a settlement that did that very thing again. While MECG believes a 25% shift is appropriate, we're willing to modify that slightly. Specifically, in its testimony, Empire suggested that residential rates should be capped at a 9.9% increase. Originally, the 9.9% increase was designed to mitigate the rate increase originally sought in this case. That said, however, Empire also said that if the overall rate increase was reduced, then, quote, principles of fairness and equity, end quote, dictate that a revenue neutral shift is appropriate. With the revenue requirement settlement in this case, the parties agreed that Empire should receive an overall increase of something around 7.5%. Therefore, as Empire points out, you can now increase residential customers to 9.9%. It will take care of some amount of the residential subsidy and would be consistent with interests of fairness and equity and recognizes bill impacts. It is critical that the commission not waste this opportunity again. As I said, in 2014 and 16, the commission took decisive steps to address the residential subsidy. In the last case, however, the commission was convinced by staff and public counsel that there was a problem with the studies because of high number of estimated bills. Therefore, relying upon this concern, the commission simply applied the rate increase in that last case on an equal percent basis. The practical effect of the commission's decision to ignore this issue in the last case was to undo all the efforts that had been made in previous cases. As you can see from this chart, several classes, as you work from right to left, the far right for each one is the 2014 case, then the middle color is the 2019 case, and now this case. So if you look at like the large power class, what you see is the overall rate of return for that class is now going up higher and higher and higher. In the meantime, the residential class on the far left has seen its earned rate of return go down. What that means is because the commission didn't do anything on this issue in the last case, the problem has now been exacerbated. I'll just wing it from here. What is the implication of having large commercial and industrial customers pay rates that are above cost of service?
Mr. Wixmo, would you like me to get someone in here too?
Let me see if I can. Okay, we'll just leave it on there and I can finish up. What is the implication of having large commercial and industrial customers pay rates that are above cost of service? In just a few words, the residential subsidy means that industrial rates are not competitive. In 2011 and 2014, the Commission discussed the need to eliminate subsidies and have classes pay cost-based rates. For instance, in 2014, the Commission specifically stated that, quote, competitive industrial rates are important for the retention and expansion of industries within Empire's service area. If businesses leave Empire's service area, Empire's remaining customers bear the burden of covering the utilities fixed costs with a smaller number of billing determinants, end quote. In other words, while residential customers may think that they're getting a great deal with the residential subsidy, they may end up paying more later. Eventually, industries will leave Empire's service area for cheaper rates in other parts of the state and the nation. When that happens, residential customers will pay more. There is an old adage in an oil filter commercial where a mechanic says, you can pay me now or you can pay me later. That adage is equally applicable here. The residential customers may think they're getting a break now, but when industrial customers leave, they'll end up paying for it. So how competitive are Empire's industrial rates? They are terribly uncompetitive. Here you see a chart that is based upon the EEI Typical Bills and Average Rate Report. What you see here on the far left is Empire's average industrial rate. This shows that Empire's average industrial rate is 22% above the Missouri average industrial rate, about the same above the regional average industrial rate, and about the same above the national average industrial rate. You can see all three of those others run about 6.7%. But in Empire's service area, because of the significance of the residential subsidy, it's almost 8.3%, 8.3 cents per kilowatt hour. And the situation is getting worse. In 2015, the Empire industrial rate was 17% above the national average. In 2019, the Empire industrial rate was then 21% above the national average. Now, after having ignored this problem in the last case, Empire's industrial rate is now 24% above the national average. It's time to wake up and address this issue. In its testimony, OPC tried to make light of this sobering situation and claimed that the same dynamic exists for all Empire's customers. This is inaccurate. As you can see in this table, Empire's residential rate is only 3.6% above the national average, basically right at the national average. Empire's commercial rate, only 5.4% above the national average. Only the industrial rate sees this huge problem, 24.3% above the national average. In another effort to make light of this drastic situation, staff questions the reliability of the EEI data. Noticeably, staff doesn't provide anything better. It just questioned whether the data can be used. But as we've seen, EEI data is used routinely by utilities, commissions, and customers. Data request responses show that the EEI data is used by Excel, Evergy Metro, and Evergy West to assess the competitiveness of its rates. Commissions, as I told you in 2014, the Commission expressly relied upon testimony that utilized that EEI data. Finally, customers use it. As Steve Chris and Rick Nelson noted in the 2019 case, while the values are based on averages, the rankings can still be meaningful as customers seek to benchmark their energy costs against other utilities and regions and use those to assess competitiveness of utilities. Like staff, public counsel also didn't conduct a class cost of service study. Unlike staff, however, public counsel does not question the accuracy or reliability of the two studies in this case. Rather, public counsel, on behalf of its client, the residential class, throws itself on the mercy of the Commission. Specifically, public counsel points to inflation and uncertainty surrounding the ongoing COVID pandemic. The evidence indicates, however, that these factors are equally applicable to all customers. They are not unique to the residential class. Frankly, public counsel has a litany of excuses to get the commission not to address the residential subsidy. Estimated bills, unreliable data, COVID, inflation, unemployment, you name it, they have a book upstairs where they can find an excuse to keep you from addressing it. As Commissioner Roop noted just last week when deliberating the Ameren case, quote, the argument is made that this is not the right time to do it, address the residential subsidy, quote, because it's never the right time to do it, end quote. That's public counsel's playbook. Don't do it now because of COVID. Don't do it now because of inflation. But if those factors go away, in the next case it will be unemployment or something else. It's never the right time. As Commissioner Root noted about public counsel's position, it's never the right time to address it. That's the extent of my comments. Just urge the commission to go back to what they did in 2014 and 16 and take steps to address the residential subsidy in this case. Thank you, Your Honor.
Thank you. Are there any questions from the commission? And I'll remind everybody who's participating via phone, you want to dial *6 to unmute. I hear no questions, and I have no questions at this time. We're going to go off the record for just a moment while we set up for the next opening statement. And we will go back on the record now. Is there an opening statement from the Empire District Retired Members and Spouses Association?
Yes, good morning, Judge and Commissioners. Just a brief opening statement. As Ms. Carter indicated in her opening statement, EDRA has entered into a stipulation and agreement on its one issue with the company. The association represents retirees of Empire, which was acquired by Liberty in the merger case in 2016. And so these are sort of the legacy Empire retirees. An agreement on post-retirement benefits was approved in the stipulation and agreement in that 2016 merger case. The purpose of the new stipulation in this case is to clarify some of the language from that original stipulation and agreement. It also gives the company some flexibility to transition those retirees into a new plan, so long as the benefits stay materially similar to the existing plan. We would urge the commission to approve it. We also believe that it's just and reasonable to do so. And with that, I would take any questions.
Any questions from the commission? I have no questions, but what I am going to do at this time is say that, just for clarification, there are 4 filed partial stipulations in this case that are meant to resolve all but the class cost of service issue. I had set this as a hearing for 2 days, but what it is today is the evidentiary hearing in regard to the class cost of service issue, which is the issue up for the commission's determination. Tomorrow is the on-the-record presentation for commission questions. These are 2 separate hearings. I don't want to muddy the record in this case by combining those 2. So you're welcome to make whatever opening statement you would like to make today, certainly. Does EDRA have a position on class cost of service they want to put forward, or did you just want to talk about the stipulation at this point?
No, Judge, yes. I just wanted to talk about the stipulation. I was going to ask for leave to be excused from the rest of the hearing today, and obviously available tomorrow to come back and answer any questions about the stipulation.
Okay. Is there, and it's possible that we may move to give the commission more time to look at that stipulation. It's possible that we may move tomorrow's hearing date, but I will have to check on that. But to address one thing at a time, is there any objection to the commission excusing EDRA from the rest of the hearing?
Certainly not.
I see no objections. Mr. Jarrett, thank you very much. I'll grant your request and your excuse from the rest of the day's hearing, and I hope that you will certainly come back and talk about the stipulation for the on-the-record presentation.
Absolutely, we'll be here. Thank you, Judge.
Thank you. Mr. Whitsmall, do the SERP retirees have any opening statement that they wanted to make?
No, Your Honor.
City of Ozark and Renew, as I've said before, have both asked to be excused from today's hearing, and that was granted in both cases. So we're now ready to take witnesses in this case. Does anybody at this point need to take a break?
No, Your Honor, but I did want to bring up something. We never spelled out an order of cross-examination in the second issues list. In the very first one that had a multitude of issues, we did. I believe the situations are different, and we usually do cross-examination in order of how opposed parties are. So I would say that I would probably cross-examine Empire's witness first, but similarly, I think staff and OPC on their witnesses, I should get to cross-examine last.
Okay, well, why don't we look at this? I was looking at the order of cross, and the way I have it right now is there, EDRA has asked to be excused. Are the SERP retirees going to have any cross-examination?
No, Your Honor.
Okay, then let me go through the order of cross minus all the parties that have asked to be excused and minus those parties that have indicated they do not have a cross-examination. And from that, we'll see if we can cobble together an order of cross. Now, for Liberty, for witness Tim Lyons, I currently have MECG going first for cross-examination, followed by staff and OPC. Any objection to that order? I see none. In regards to staff's witness, Sarah Lange, I have MECG, followed by OPC, and then Liberty. Any objection?
Yes, I believe, given that MECG is most opposed of the parties, that we should get to do cross-examination last.
Any objection to that? I see no objection. So cross-examination for staff's witness will be OPC first, followed by Liberty, followed by MECG. For OPC's witness, Dr. Jeff Mark, I have MECG, followed by staff, followed by Liberty.
Same point, Your Honor. I believe the MECG should go last.
Any objections from any party to MECG going last? Okay, I see none. The new order of cross-examination for OPC's witness is staff, followed by Liberty, followed by MECG. And finally, for MECG's witness, is it Maney? Maini, I apologize. Maini, I have OPC, followed by staff, followed by Liberty. Any objections to that order of cross-examination?
We believe that Empire should go first, followed by OPC, followed by staff.
Any objections to that? Okay, the new order of cross-examination for MECG's witness is Liberty, followed by OPC, followed by staff. Now, I've got this penciled in as best I can. If for some reason I accidentally deviate from that, I'd rather you stop me before questions get asked, but I will do my best to adhere to that order. Okay, given that nobody indicated they wanted to take a break at this time, but it is my intention to take a break around 11 o'clock, between 10:30 and 11. Why don't we go ahead and hear from the first witness, and if we need to break in the middle of that witness's testimony, we will. So, Liberty, call your witness.
Tim Lyons?
Okay. Mr. Lyons, would you raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give at this hearing is the truth?
I do.
Thank you, Mr. Lyons. Okay. Liberty, you can commence with your direct examination.
Thank you. Mr. Lyons, if you will please state and spell your first and last name.
Timothy S. Lyons. Last name is Lyons.
By whom are you employed and in what capacity?
I am with Scott Madden, and I'm a partner.
Are you testifying today on behalf of the Empire District Electric Company?
Yes, I am.
Did you prepare and pre-file direct, rebuttal, and sur-rebuttal testimony in this matter that has now been marked and admitted as Exhibit 36, 37, and 38?
Yes, I did.
Do you have any corrections for your pre-filed testimony?
No, I do not.
If I were to ask you those same questions today, would your answers be substantially the same?
Yes, they would.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes, they are.
Thank you. I tender Mr. Lyons for cross-examination.
Thank you, Liberty. First to cross-examine Liberty's witness is MECG.
Thank you, thank you, Your Honor. Good morning, sir. Can you hear me?
I can. Thank you. Good morning.
So it's my understanding that you conducted, or your firm conducted, the class cost of service study presented by Empire in this case. Is that correct?
That's correct.
And the only other class cost of service study in this case was filed by MECG. Is that your understanding?
Yes, it is.
Were you here for my opening statement?
Yes, I was.
Would you agree that as far as Empire's class cost of service study and MECG's class cost of service study, there were initially 3 differences? Is that a fair assessment?
I have not done a side-by-side comparison of the 2 studies, but I think the issues that you identified were the major differences.
Okay, let's walk through those. First off, just as some background, can you tell me how the average in excess is calculated?
Sure. The average in excess is it's a production plan allocator, and it reflects that that the plants are designed to meet both energy and demand requirements. And so it's really split into 2 different allocators. First is the energy allocator that's developed based on energy load throughout the year, the KWH. And then the second would be the peak demands, and it looks at non-coincidental peak demands by class and apportions the other piece of the allocator is based on those non-coincidental demands. So the average in excess is a combination or of both the energy and the peak demand components.
And can you tell me how the system load factor is then utilized in the average in excess calculation?
Sure. When you put those together, the energy and the peak demands, the question is what % would you use that's energy and what % would be peak demands, because they're separate allocators. And what the load factor does is you look at the system load factor, and then based on that percentage, you would apply it to the energy, and then the remaining percentage would be peak demand. So in this case, the energy portion would be based on the load factor, and the peak demand would be 1 minus the load factor.
And originally, there was a difference between MECG and your study in how that load factor is calculated. Is that true?
That's correct.
And it was my understanding that you had originally used a load factor calculation that looked at all 12 months, and that MECG looked at one single annual system load factor. Is that accurate?
Yes, that is.
And in your rebuttal testimony, you agreed to the use of one single system load, peak for calculating the load factor. Is that accurate?
Yes, except what we said is we wouldn't oppose it. You had that in your
Okay.
slides as well.
And then there was an issue between the MECG and Empire class cost of service study in the method by which interruptible credits are allocated. First off, can you tell me what interruptible credits are?
Sure. These are credits that compensate interruptible customers for foregoing having firm service. So at the time of peak demand, the interruptible customers will leave the system or not add to that demand. So the credits are a way to compensate customers for interrupting their load or not being on the system at the time of that peak demand.
And can you describe what the difference was between the way these credits were allocated among the classes between the Empire and the MECG studies?
Yeah, so in the Empire study, the credit was applied to all of the customer classes, including the interruptibles. And in the MECG study, it was applied to all of the classes except the interruptible class. And we agreed with that application.
Okay, so that difference has been resolved between MECG and Empire, is that correct?
Yes, it has.
Okay. Finally, it is my understanding that initially Empire used an average and excess that was based upon the peaks for all 12 months. Is that correct?
That is.
And is it fair to use the acronym 8NCP for that variant?
Yeah, so the original was a 12 NCP, so it was using all 12 months. And then in our rebuttal testimony, we reverted to the NCP using 8 months.
Okay, and MECG agreed that the 8NCP version of the average and excess was appropriate as well. Is that true?
Yes, that's correct.
So that difference has been resolved between MECG and Empire as well. Is that correct?
Yes.
Okay. And I believe at the very beginning you mentioned that there were those were the three major differences between the Empire and the MECG studies, correct?
Yes.
Okay. So would you agree then that there are no longer any major differences between the two class cost of service studies?
Yes, I would.
Okay. Moving on, staff leveled a number of criticisms at your class cost of service study and at the use of the average and excess methodology. Did you read those criticisms?
Yes.
First, do you believe, did you by any chance have the opportunity to read the Ameren order from last week where they adopted the Ameren class cost of service study?
I've only read a very small section of it.
Okay. Is it your understanding that Ameren utilized an A&E allocator for fixed production costs?
I didn't look at that section, unfortunately.
Okay. Do you believe the average and excess allocator is still relevant?
Yes, I do.
And that hasn't changed based upon the introduction of the SPP integrated marketplace?
No, it hasn't.
And would you agree that the average and excess allocator is widespread in its usage by state utility commissions and vertically integrated states?
I haven't done a study on it. I know it's used in other jurisdictions. It's included in the NABRUC Electric Utility Cost Allocation Manual, and it's generally accepted. It's generally one of the accepted methodologies for allocating production plant investments.
Do you recall a criticism from staff that demand data, as it's used in the average and excess methodology, is unreliable?
Yes.
Do you agree with that criticism?
No. And no.
Can you tell me why you don't agree with that criticism?
Well, first, it's data, and it's an approach that the company has been using for a number of years now. It's based on load research information that it has, where it's measuring actual customer demands across the service area. And in staff's criticism, we didn't see any data or analysis or studies that would support exactly why this data couldn't be used in this case, but it was used in other cases.
So what you're saying then, if I may try to summarize, you're saying that staff made the criticism, but then didn't provide any real justification for that criticism.
Yeah, as I said, we just didn't see any data analyses or studies that ended up supporting that position, that the demand data could not be used in this study.
Did you also see staff's criticism about concerns with rate switching, that is migration between customer classes?
Yes.
You believe that is a valid concern in this case?
No, so I spoke with the company about this, and their reference was that the rate switching occurs in any year, and that in the test year that there wasn't any extraordinary switching that occurred that would create concerns for using the data.
And would you agree that rate switching is a phenomenon that is not unique to Empire, that it happens with all utilities?
Yes, I would agree with that.
Staff also criticized your study because it allegedly relies extensively on class peak demand. Are you familiar with that criticism?
Yes.
And do you agree with that criticism?
No, that was one of the reasons for using an average and excess production allocator, where it's based both on energy and peak requirements. As I mentioned earlier, the average requirements would be the kWh demand throughout the year, and then the excess piece, or the peaking piece, would be related to those non-coincidental demands by class. So it's a combination. It's a combination allocator, both energy and demand.
So if a party was to propose, for instance, a 1 CP methodology for allocating fixed production costs, that would rely entirely on class peak demand, is that correct?
Yes, that's correct.
And the A&E, as proposed by both you and MECG and Ameren, all rely more heavily on class energy usage than class peak demand, is that correct?
Well, by that, the percentage that's related to the energy allocator is higher than the percentage that's related to the demand allocator. That's correct.
Okay. Staff criticized your study because you allocated SPP revenues on the basis of the energy allocator. First off, can you tell me what SPP revenues are?
Yes, my understanding is that any production that Empire has, they can sell it into the market and be able to accrue revenues associated with it.
And would you agree that the cost, primarily fuel, needed to derive those SPP revenues are allocated amongst the parties based upon an energy allocator?
Yes, that's correct.
So by allocating the revenues on the basis of the energy allocator, you're simply replicating the same allocator for both the cost and the associated revenues.
Yes, that's correct. In the Sir rebuttal testimony, we pointed out that there is additional, or there's isolated revenues related to the wind investments. And so in that case, there would be no incremental expenses associated with that. And so those revenues were apportioned based on the A&E allocator, which is consistent with how the investment is allocated. So that's the one exception to that.
Okay. Finally, at page 7 of your Sir rebuttal, you state that you believe that your class cost of service study provides, quote, important guidance on the allocation of any revenue requirement. Do you still believe this?
Yes, I do.
Okay. You filed testimony in Empire's last electric rate case, is that correct?
Yes, it is.
And is it correct too that in that case, you proposed to address the residential subsidy by placing a greater amount of revenue responsibility on the residential class versus the other classes?
I haven't reviewed that testimony, but subject to check, I would agree with that.
Okay. Are you aware that Empire has also filed a gas case that is pending as of today?
Yes,
And you filed class cost of service testimony in that gas case, is that correct?
that is correct.
Is it your understanding that in that case, the company is seeking an increase of 6.7% in base revenues?
I don't have those numbers in front of me, but I'll accept your representation at this point.
Okay. And would you agree that your class cost of service study in that case showed that residential class should receive a revenue neutral increase of 22.4%?
I'm going to object on the basis of relevance, Judge.
Mr. Woodswell, do you have a response?
Just trying to show how the methodology that he is using in this case, how it is consistent or inconsistent with that gas case.
Mr. Thompson?
Gas and electric are two different things, Judge, and I'm not even sure that the service territories are the same. I don't see the relevance of what's being done in the gas case to what is being done in the electric case.
I'll give you gas is different than electric. I'll also give you that the service areas are somewhat different. The methodologies and how he applies revenue allocation are relevant to each other.
Why?
Why? Well, what I'm going to show is that how he used it. In this case, he is proposing a 9.9% rate cap on residential customers. In the gas case, he proposed the same thing. I'm going to show why those target revenues are consistent in how he's using it.
Why does it, I don't understand why it matters if he chose a number, the same number for gas as for electric. I don't see what those have to do with each other.
Well, in the electric case, originally the company had an overall increase greater than 10%, and he used the rate cap to justify a lessened system average to the residential class. In the gas case, it's just the exact reverse. That's where it started. Now that we have a settlement, I want to ask him if his position in this case has changed. And I'm just trying to provide some foundation, some background to get to the point of asking whether his position has changed.
Judge, the fact that he just characterized the position of his witness in the two different, in the gas case as being the exact reverse shows that it's irrelevant to this case.
It was the exact reverse. It is no longer exactly reversed.
I think you can ask him if his position has changed without dealing with the gas case. So I'm going to sustain the objection.
Okay, let's see how I get to that. Yes, this. Okay, so in this case, is it your understanding that Empire was originally seeking an increase in excess of 10%? Sir, can you still hear me?
Yes. The overall increase exceeding 10%? I don't think so. That's not my recollection.
In the original case, with the URI increase,
Oh,
you used a rate cap for residential customers of 9.9%, which was less than the system average. Is that correct?
yes. When you added URI in there, now I understand the numbers. Yep. Yes.
Okay. And so the rate cap that you used in this case was designed to limit residential customers to an increase below system average. Is that correct?
It was there was no rate cap. It was simply just recognizing what the bill impacts would be for the customer and managing that relative to the overall increase for the residentials. But there wasn't a hard cap or established cap that the company had.
Okay, it was, I'll use the words, I think you used target revenues. Is that correct?
Yes.
Okay. And are you aware that the revenue requirement in this case is now settled?
Yes, I am.
And would you agree that the settled revenue increase is about 7.5 or 7.6%?
It's in that I think the number that you had up on your chart was somewhere around 7.6%. So I think that's generally within the range of what I thought it would be.
Okay. In your rebuttal testimony, you originally said that you agreed with the principles of MECG's revenue allocation. You talked about principles of fairness and equity, but you said that that should be, you should also consider bill impacts. You recall that?
Yes.
And now that the settled rate increase is 7.6%, would you agree still that a 9.9% increase for residential customers considers bill impacts while now supporting the principles of fairness and equity?
No, the testimony that the company and the position that the company has taken is really supporting, it's more principle based than numbers based. And so there was no hard cap, as you said earlier, or there was no hard percentage in terms of what it means to be subject to bill impacts. And so, as we discussed earlier with the cost of service study, it's really focused on measuring what does fairness mean or what does equity mean. So how does the cost of service apportion to each of the classes relative to the revenues? And that's really focused on the principles around fairness and equity. In terms of bill impact, that has more to do with what the overall impact is on the rate. So how much would the rates go up relative to the current levels? So those are concepts that kind of work together. And at this point, like I said, that there's a framework that's been established, but the company's not taking a specific position as to beyond what's already in the testimony in terms of that framework.
Okay, now I'm really confused. So as far as setting target revenues in this case, you and the company were originally okay with the residential class receiving a 9.9% rate increase. Is that correct?
The original target was based on that amount, yes.
Okay. how has that been changed now that the settlement provides for a 7.64% overall increase?
Well, like I said, it wasn't, there wasn't a target in terms of what the bill impact would be. So there wasn't an established amount that the company had that said that based on any level of increase, this is the amount that the residential customers would see. So it wasn't that hard cap of saying, okay, it must be 9.9. It was looking at the overall increase for the company, which at that time, the base rate increase was around 52 million. And it looked at that relative to what impact that would be on the different classes, including the residential class, and decided that it was reasonable to have that 9% increase for the residential relative to the overall increase, with the overall company increase of that 50 to 52 million. How that translates into the settlement, that's something that the company hasn't taken a position on, other than the fact that it still has the framework in place, which is balancing the fairness and equity issues relative to the bill impacts.
And that's what I'm asking you to do, to take a position as the expert here today on what is the appropriate increase to the residential class in light of principles of fairness and equity and in light of a settlement of 7.64%.
Yeah, and beyond the framework that I mentioned, just balancing the fairness and equity relative to the bill impacts, that's as far as that the company is going at this point. Is the framework is still in place? Going back to your earlier comment, where's the consistency? That's the consistency of looking at fairness and equity relative to the bill impacts, how that translates into what that revenue target, what that means for the residential class, that's beyond the stated testimony at this point.
I appreciate that, and I appreciate that the company hasn't gone that far. You are the expert here today. You've testified on this issue in other cases umpteen times. Let's start this way. Do you believe that an increase for the residential class of something above 7.64% is appropriate?
I'm going to object, Judge. He's badgering the witness. The witness has already answered the question that the company has not taken a position.
And I'm asking for his expert opinion.
I disagree. I actually, in all of the things that Mr. Lyons has said, I did not hear whether his position has changed or not. I heard a lot of talking around that point, but my understanding from his testimony was that it was 9.9% when it was when URI was included in the request, and he hasn't actually answered the question. So I don't believe he's badgering the witness. He just hasn't had his question answered. So I'm going to overrule your objection.
Thank you, Judge.
Your Honor, or excuse me, Mr. Lyons, to restate this, let's start with, given a settlement of a 7.64% revenue increase, do you believe that it is appropriate, fair, equitable to increase residential rates by more than 7.64%?
Let me put it this way, that an increase beyond the 7.6 can be supported by the results of the class cost of service study. However, any increase would need to be subject to any bill impact considerations.
And when you previously filed testimony, you said bill impact considerations allowed for an increase to residential customers of 9.9%. Is that correct?
Yes.
And can you tell me why, if bill impact considerations allowed for an increase of 9.9% before, why it wouldn't allow for an increase of 9.9% now?
Well, there's, in looking at any of the designs, right, it's not just one factor. So you're just focused on, one factor. And it's really, there's a number of factors that play into setting the overall design. And it's not, it's not, there's just a lot of factors, and there's no rule of thumb when it comes to setting these, balancing the equity and the fairness relative to the impact. And that's what I'm trying to get across.
But what you said in your direct testimony and what you've said repeatedly today is that bill impact considerations led to a recommendation of 9.9%, correct?
Yes.
Can you tell me why those same bill impact considerations would not allow for that same 9.9% increase for residential customers given the reduced revenue requirement?
Well, the circumstances are different. The overall increase is different, and that would be a consideration in terms of what you would look at on a relative overall increase for one class versus another.
So,
go ahead.
Bill impact considerations always work in the favor of the residential customers? Is that what you're saying?
Not necessarily. I think in some cases, maybe even in the last case, I think there were some special considerations given to the industrial class, for example.
And that's what I was asking earlier. In your testimony in the last case, you agreed that the residential customers should receive an above system average increase.
Yes, that's what I recall. And I recall at the same time that I think on the industrial side as well, that there was special consideration given to that increase for the industrial. So I was just responding to your earlier question. It's not only focused on the residential, but it also include the industrials as well.
Okay. And even though your recommendation in the last case was, quote, to give special consideration to the industrial customers and provide a system average increase over a system average increase to residential customers, the commission did not adopt that position, did they?
No, that's correct.
And would you agree that the magnitude of the residential subsidy has increased since that last case?
I'm just looking at the graph that you showed earlier, which is that unit rate of return. It looks at the class rate of return relative to the system ROR. And if I look at that chart, so this would be in the Sir rebuttal testimony, Exhibit 38.
I'm relying on something that's not in evidence in the case.
He's referring to where it is in evidence.
On page 6, within that Exhibit 38, which is the Sir rebuttal testimony. I don't have the numbers in front of me. All I have is this visual, and it does look like the return, the unit rate of return for the residential.
Mr. Lyons, hold on just a second.
Sure.
Mr. OPC's objection will be overruled. Go ahead and answer, Mr. Lyons.
Okay. So if I look at that graphic, I don't have the numbers in front of me. I only have that figure 1, page 6, Sir rebuttal testimony, which has been marked as Exhibit 38. It looks like the blue bar, which is the 2021 class cost of services, is just a shade higher than the 2019. So what that would mean is that the return is a little bit higher for the residential in this case than it was in the last case.
But still well below where it was in 2014, is that correct?
Yes, that's correct.
And you would agree that under all three of those studies, there is a residential subsidy in that the residential class is not paying its full rate of return. Is that correct?
Yes, the return of that class is below the unit rate of return or less than the overall company rate of return in each of those studies.
Okay, let's look at some, on that same table then, let's look at some of the other classes. Would you agree that the LP, the large power class, is generally the industrial class?
Yes,
And would you agree that since the last case, the large power class is paying even more above cost-based rates than it was in the last case? Is that correct?
yes, I would agree that that unit rate of return has increased from 14 to 2019 and then again in 2021.
And we see an even more dramatic increase for what is labeled as the SCP class. Is that true?
Yes,
So what all those show is that industrial customers are paying even more above cost-based rates since the last case. Is that true?
yes,
Okay, you were saying earlier that your recommendations depend on the context of a case. Your recommendations regarding revenue allocation depend on the context of the case. Do you recall that?
yes.
Okay, and just to test that out after he said it, can you tell me what your recommendation was in the pending gas case?
Well, the approach was the same, which is looking at the class cost of service.
Hold on, Mr.
And-
Lyons. I did sustain the objection to that. I believe that information was already out, though, prior to the objection.
Very well. Let me repeat the question, Your Honor. Can you tell me what your revenue allocation recommendation is in the context of that Empire Gas case?
It's a similar approach to what's done in the Empire Electric, which is to perform the class cost of service and then based on the principles of fairness and equity, subject to bill impacts, establish revenue targets. I don't have the case in front of me. I don't have the numbers in front of me, so I don't want to at this point just go pure on memory of exactly what all those allocations are. So, but it's the same principle, same approach, and same conditions around bill impact considerations.
Well, would you agree in that case that your recommendation was for the residential class to receive above a system average increase?
I'm going to object, irrelevant.
He was saying it all depends on the context of the case. Now he's talked about the context of that case, and I'm just asking what his recommendation was in the context of that case.
We've gone outside the 9.9% that was previously out there, and you're kind of going back on track, so I'm going to sustain that objection.
Well, I'm not talking about the 9.9. I'm just asking whether his recommendation in that case was an increase that's above the system average, an increase for the residential class that's above the system average.
And right now, we're in an electric case that's kind of in hearing, and this is a case that is just, the gas case is a case that's currently pending right now.
Right, and I'm just asking.
And so it's in its beginning stages. It hasn't gone through really anything, has it?
Testimony's been filed by all parties. I'm just simply asking one question, whether his recommendation in the context of the case and given principles of fairness and equity, one question, was it above, for the residential class, above system average?
Subject to check, I'll agree with that.
Hold on, Mr. Lyons.
Sorry.
It's got nothing to do with this case, Judge.
I'm gonna allow him to ask the question.
Judge.
Overruled.
Judge, given what I heard about subject to TAC, I object to any testimony being admitted that's subject to TAC. He either knows or he does not.
If we want to go there, I have his testimony. I can take the time to send it to him as an exhibit, and we can walk through it.
You can ask him if he knows, and if he knows, he can answer the question.
Do you know, in the context of that gas case in which you filed testimony, whether your recommendation was an increase for the residential class that is above the system average?
Subject to check, I believe that's the case.
Objection. Well, you said subject to check, Judge. You say he doesn't know.
Okay, Your Honor. I need to send an exhibit.
Are you going to be getting into testimony from another case?
I'm just asking.
I mean, is that what you're asking to do, is to submit as an exhibit testimony from a gas case?
I'm not going to mark it as an exhibit. I'm going, because they're griping about the subject to check, I'm giving him an opportunity to check. And I'm sure, do you have the testimony right there, or do you need me to send it? If he was here, I'd hand it to him.
Hold on, let me think about this. Because in essence, this is a memory refresh. Well, I don't think it's very particularly relevant. I'm going to take it on weight. I'm going to allow you to refresh his memory.
Do you by any chance have your testimony from the Empire Gas case, or do you need me to
I
send
just
it?
brought it up, and I can confirm what you said. The overall was a 6.7, and the residential was a 9.9.
And your class cost of service study showed that residential needed a 22.4%, is that correct?
Yes, that's correct.
And you believe that recommendation in that case was consistent with principles of fairness and equity, is that true?
Yes.
I have no further questions, Your Honor.
Okay, it's now 10:56. I think what I'd like to do before staff's cross-examination is take a 15-minute recess. And so or roughly 15 minutes, why don't we come back at 11:15 and we will go off the record. Okay, let's go on the record. There was a slight delay as we needed to discuss off the record some scheduling issues. We're going to pick up. We're going to pick up where we left off with Mr. Lyons' testimony, and it is staff's cross-examination. So staff.
Thank you, Judge. I'll try to make this brief. How you doing, Mr. Lyons?
Hi, how are you? Good morning.
I'm okay, thank you. I wonder if you could tell me what is the percentage increase that you recommend for the residential customer class, if in fact you have a percentage increase that you recommend?
No, there's no percentage increase at this point.
And am I correct in understanding the general increase to be 7.64%?
Yes, based on the settlement.
And would you have any problem with a 7.64% increase for the residential class?
No, that can be supported based on bill impact considerations.
And if you know, is Empire deploying improved meters in the near future?
Yes, the AMI meters.
And will those meters provide a significantly improved data set for class cost responsibility shifts in the future?
It will provide more data. Whether it's better data or not remains to be seen based on the results of that data.
Okay, but it could be better data, isn't that correct?
It could be. It'll certainly be it'll be more data, and if the data is good, it'll be a full population as opposed to a sample population.
Okay, and you made revisions to your class cost of service study in your SIR rebuttal, isn't that correct?
Yes.
And that's because your original study, in fact, was incorrect. Isn't that correct?
The update that was provided in the SIR rebuttal include 3 changes. One was just update the revenue requirements. The second was the wind allocation, which I mentioned earlier. And the third was to revise the allocation of the interruptible credit. Those were the 3 changes.
Okay. But wouldn't you agree that that made your SIR rebuttal study more reliable than your direct study?
It made it a little more precise, especially, for example, around the wind allocation and then the interruptible credit. But it's yeah, more precise.
The chart that Mr. Woodsmall was working off, was that based on your direct study or your SIR rebuttal study?
It was based on the direct.
So it was not as precise as it could have been, isn't that correct?
Sure, yes.
Okay. I have no further questions. Thank you.
Cross-examination from the Office of Public Counsel.
I think just a few questions. Mr. Lyons, at this point in this case, the Asbury impacts on rates and the Storm Uri impacts on rates are not part of the company's position at this time, are they?
Yes, that's my understanding. It's not part of the base rate increase.
And with those changes, do those impact what you would recommend for class revenue shifts? From what you put in your pre-file testimony?
No, there's nothing in terms of recommendations. There's nothing beyond what's already been stated in our testimony, in the testimony.
But all that testimony was predicated on Storm Erie cost being, and Asbury cost being in the case, was it not?
It was a factor in the decision, yes.
No further question.
Any questions from the commission? Okay. I have one just because I believe it's been answered, but we kind of danced around it to Mr. Lyons. I think as MECG asks you, your position originally in your direct testimony was a 9.9% shift. Is that correct?
It's not a 9.9% shift. It was a 9.9% increase.
Okay, thank you for clarifying that. And MECG asked you if your position had changed, and it appeared that you went from having a position to no longer having a position. Is that correct or is that incorrect?
Well, in the direct testimony, it was a specific position in terms of what the increase would be for the residential class. Now it's not specific. It's more of just continuing with the same framework, fairness, equity, subject to bill impacts, but not coming out with a specific position on what the increase should be for the residential class.
Okay, thank you. Any questions based upon bench questions?
No, thank you. No, thank you.
Okay, I see none. Is there any reason this witness should not be excused?
I have some redirect, Your Honor.
Oh, I apologize. Go ahead.
Thank you. Mr. Lyons, can you hear me okay?
Yes, I can.
I have some questions, just for clarity based on the questions you received on cross-examination. Currently, Empire commercial customers are paying more than their cost of service. Is that correct?
Yes, it is.
And your testimony filed on behalf of Empire generally supports moving all classes closer to their true cost of service. Is that correct?
Yes, it does.
You stated in response to Mr. Thompson's question on behalf of the staff of the commission that your testimony in this case could support a residential increase of 7.6%. Do you recall that?
Yes.
Is it accurate that your testimony and the rate design principles discussed in your testimony could equally support an increase in the residential rate anywhere between the 7.6 and 9.9?
Yes, it could.
That's all I have. Thank you.
Any recross? See none. All right, Mr. Lyons, you're excused.
Thank you.
Your Honor, before we move on to the next witness, as you know, several parties filed a stipulation on Saturday morning. While MECG originally indicated that it did not oppose that, we have now reconsidered that, and it's likely that we will be opposing that stipulation. I don't believe it's still within our statutory timeline, and I don't believe it's prejudiced anybody because that was filed on Saturday, and here we are on Monday morning. So we are continuing to look at that, but I just wanted to make you aware that we may be filing that objection.
Okay, you say that it didn't, you don't believe it's prejudiced anyone, but that was what reduced it to the number of issues we have today. So I'm assuming that based upon that, that you would be asking that all of these issues go back into play.
Correct. And this is being filed on the first business day after that objection or after that stipulation was filed. So it's not like days of the hearing were canceled in light of that stipulation. This objection is the first business day after that stipulation.
Well, certainly Friday was canceled in anticipation.
in anticipation. So I'm just making you aware, we're considering that.
Okay, thank you. All right, our next witness is from staff. Staff, you may call your witness.
It's my understanding that the parties are all in agreement to waive cross on Ms. Lange.
Correct.
So staff doesn't see any point in calling her at this time.
Okay, so you since her testimonies have been admitted, you have no direct you wanted to ask.
The parties have waived cross, so I think Ms. Lange is free to leave.
Is there any party not waiving cross on Ms. Lange?
As long as the commissioners have no questions, certainly.
Does the commission have any questions for Ms. Lange? I hear none. I have no questions for Ms. Lange, so we will rest on testimony in the record.
Yes, Judge, thank you.
Okay, Ms. Lange, you're excused. Okay, Mr. OPC, would you call your witness?
I believe the same circumstance applies to Mr. Mark.
Is there any party that has questions for Mr. Mark?
No questions, Judge.
No, Your Honor.
Liberty, I see a head nod. Is that?
Oh, that was the no question, head nod.
Okay. Okay. So OPC is just willing to rest on his admitted testimony.
Certainly.
Any commission questions for Dr. Mark? I hear none, and I have none. I'm getting some feedback. Does somebody have a question for Dr. Mark? Okay, I hear none. I have no questions. Dr. Mark, you're excused.
Oh, yeah, we already, we waived that.
So I guess we're up to my witness, Your Honor.
Okay, MECG's witness.
And just to be clear, what I'm being told now is that the other parties are willing to waive on her.
That's correct.
Okay, which brings me to my next issue. Given that you've indicated that you're going to object, do we come back this afternoon and start the remaining issues? Because that seems to be where we are.
I think it's necessary, yes, Your Honor. We'll know by the end of the day whether we're going to file the objection, but I think in order to try to get as close on schedule as we can, I think it's necessary.
Do you have cross for anyone?
Everything's admitted.
We all just waive cross on everybody?
We can do that.
Okay, so there's currently no, there are no questions for any from any party for Ms. Miani? Maini, thank you. Are there any commission questions for Ms. Maini? Okay, I hear none. I have no questions that come to mind. So you're willing to rest on her admitted testimony?
Yes.
Okay. So I don't have any more witnesses for this issue. I don't know at this point. Here's what I'm going to do. I'm going to go off the record so that we can discuss some scheduling matters. I think that's probably the appropriate thing to do. So we will go off the record for a few minutes. All right, we're going to go, well, let everybody know we're going back on the record.
Watering hole here.
Okay, we're going to go back on the record. We are going to take an early lunch until 1 o'clock to give the parties an opportunity to discuss how we are going to conduct the remainder of the case and see if they can agree on a schedule and what issues need to be resolved by the commission. So with that, we'll return at 1 o'clock and we'll go off the record. Okay, do I have a court reporter?
You do.
Okay, thank you, Ms. Taylor. We will go back on the record now. It is 1 o'clock. Hope everyone had a good lunch. Bear with me just a second. There we go. That's what I want. Okay, when we left off, we had finished presenting evidence in regards to the single issue that was up for today. At that point, Mr. Woodsmall had indicated that MECG would be filing an objection to the, I believe, fourth stipulation. Is that correct?
Yes, Your Honor. So, during the break, we had some discussion about some of the events that occurred this morning and to try to clarify, some positions. And I think the company is going to clarify its position, which will alleviate my need to object.
Okay, and how are we planning on doing this?
Judge, if I could just make a statement that would effectively add to or amend our position statement in light of the stipulation, if that works for you. It's just very short, whole statement.
Is that acceptable?
Yes, Your Honor.
Okay, if that will resolve the issue, I'm certainly happy to do that. Let me ask, just because I want to be sure I've covered all my bases, is there any other evidence that needs to be presented this time in regards to class cost of service?
No.
And everybody's gotten everything into the record they wanted in the way of testimony and evidence?
Yes, Your Honor.
Okay, Empire, if you indicated that you wanted to clarify the position of the Empire District Electric Company, is that correct?
Yes.
Okay.
Judge. We filed position statements, of course, based on the list of issues at the time. And since position statements were filed, the stipulations were entered into and submitted to the commission for consideration. With regard to the one remaining contested issue, we wanted to clarify the company's position. Given the stipulations, particularly the fourth stipulation, if you then couple that with Tim Lyons' testimony and the fairness and equity considerations in his testimony, the company would recommend an 8.3% increase for the residential class. And in relation to our understanding of OPC's rate proposal, based on the stipulation.
I'm sorry, Miss Carter, you were breaking up there. I got the residential class and in relation to our understanding.
Our understanding of public counsel's rate design proposal as applied to the stipulation would be an increase to the residential class of approximately 7.6%. So again, that would be the company's recommendation would be a residential increase of approximately 8.3% in relation to that 7.6%.
Okay. Okay, I've noted that. Does anyone else have anything they want to say on that topic? Okay, I've asked again, are there any, hold on just a second, let me get to my, I've addressed issues. Ms. Taylor, when do you have transcripts currently set to be done?
I don't have an expedited order, so right now it's 2 weeks.
Okay. Can you give me a date? And I'm not ordering any expedited transcript.
All right, give me just a second here.
Since it's only half a day a hearing, can we get it sooner than 2 weeks? I mean, I don't need it expedited like Wednesday, but given it's just a half a day, I could put something earlier.
Okay. Ms. Taylor, what date did you say again? I'm sorry?
Okay, so it would be the 22nd of February.
22nd. And initial briefs are due the 25th, is that correct?
It's something like that. I don't have that date.
I'm reluctant to order an expedited transcript when we are only discussing one issue.
Currently, Judge, I have on my calendar, briefs are due on February 24th.
If I moved it to the 25th, would that work for everybody? That gives an additional day.
The 24th.
If it's possible to do the brief or the transcript in 10 days, that would be better, but I don't understand those logistics.
There are logistics involved. It's just
Okay.
not, it's not something we like to order unless there's an absolute need for it. And given that there's only one issue involved, I think it'd be easier to move the due date of the briefs by one day than do that. So I'm going to move the dates for initial briefs to February 25th. Is there any reason that I would need to move the responsive briefs from the March 11th? Okay, I see no input on that. All right. At this point in time, and there's going to be a little bit more discussion on it, but at this point in time, I'm thinking that we will probably want to do an on-the-record presentation where the commission can ask questions about the filed stipulation this Thursday, the 10th. Is that going to be a problem for anyone? And I will provide a WebEx number for any witnesses who would like to be present via WebEx.
Judge, would that be at 9 o'clock?
That, I really don't have a preference between 9 or 10. I don't know how many questions there are going to be, but typically the on-the-records don't take as long. So if the parties have a time that they would prefer, I'm certainly willing to work in regard to that. Somebody has, I'm getting some feedback, so if there's somebody who's not muted, if you could please mute yourself, I would appreciate it.
If it suits the commission, I would suggest 10 o'clock.
Okay, I'm seeing some nods. So 10 o'clock bid wins it. So as of right now, I'm planning on ordering it for this Thursday. If that changes, I will let everybody know. I will issue a written order to that effect once we've made sure that that is the date, and I will make a point to set it for 10 a.m. Are there any other matters that need to be addressed by the commission before we adjourn?
Judge, I just want to make sure it would be all right for the company representatives other than counsel to appear by WebEx on Thursday.
Yes.
Thanks.
Anything else that needs to be addressed before we adjourn?
This is counsel for public counsel. I just suggest that if the commission has specific questions of specific witnesses, if it's possible to identify that in advance, that'd be great.
If I can give anybody a heads up at all as to subjects that the commission will have questions on, I will certainly do so.
Thank you.
All right, well, I would like to thank everybody for their participation today. And with that, we will adjourn this proceeding. This evidentiary hearing is adjourned, and we will go off the record.
Thank you, Judge.